Ready to resume, Mr. President.
Session is resumed.
Mr. President, with the consent of the Senate, I move that we resume consideration of Senate Bill 2894 under Committee Report Number 200.
Any objection hearing on consideration of the measure is in order.
Mr. President, the parliamentary status is that we are in the period of interpellations. I move that we recognize the sponsor, Senator Marcos.
Senator Marcos, the principal sponsor, is that advanced.
Thank you, Mr. President.
Mr. President, I move that we recognize Senator Sotto to continue his interpellations on the
Senator
measure.
Sotto is recognized.
Thank you, Mr. President. And I gravely omitted to thank the distinguished sponsor last time that we were interpolating after I finished part one of my interpellation. So I wish to thank him now and hope that he will yield to the second part of my interpellations on the Senate Bill 2894. The distinguished gentleman from Ilocos Norte and Leyte.
Yes, certainly, Mr. President. I'm ready to be interpolated. What I believe we are now in the first part of part two of the interpolation by the gentleman from Quezon City. So I yield the floor, Mr. President.
Thank you, Mr. President. I would like to start off with Section 34, the executive authority. It is mentioned that the executive function and authority shall be exercised by the cabinet, which shall be, etc., etc. Who are the cabinet members that are being pertained to in Section 34, Article 7, and what particular departments will be part of the cabinet, Mr. President?
The Chief Minister will appoint his own cabinet, the structure of which will be decided, again, by the Transition Authority, and any additional changes, any changes to that structure will then be undertaken by the Bangsamoro Parliament. So I imagine, although there is no enumeration of departments, I imagine that it will cover the usual departments that the line departments that we see at every level of in the national and local government. There will be a Department of Finance, Department of Interior, Department of Public Works. It's a ministry. I beg your pardon. It will not be a department. It will be a ministry. Ministry of Health, Ministry of Education. I think that all of the, shall we say, major sectors will be represented, will have under, as a representative within the cabinet, a minister. So that, again, is not to be determined by the basic law, but that is to be determined by in the process of organization. And should there be any further amendments or changes to that structure, it will have to be done through the Bangsamoro Parliament.
Kasi, Mr. President, I'm looking at this as legislative powers na binibigay natin. Will that have a force of law kung silang kikreate ng mga ministries? Don't you think we should enumerate here the ministries that will be created?
We have a similar situation in local government where local sanggunians can create offices. There are some mandated positions in local government, but there are also optional positions, and beyond that, the local sanggunian can also create any such offices as they feel are necessary. This is the same power that we are giving to the Bangsamoro government, but this is not. It is on a regional level rather than on a local government level. This touches again. This touches completely on the issue of autonomy.
Autonomy. Okay.
We do not want to be dictating to the Bangsamoro autonomous region, if it is going to be a true autonomy, how their government should be structured, how the executive should be structured, and what the workings of the government will be. one of the central tenets of this of any of this or any autonomy is that these decisions, these very important political decisions, be made by the local political hierarchy.
When you said earlier that this will be part of the work that will be done by the transitional government, do we mandate that in this bill?
Yes, that is part of the transitional procedure. Once for example, this is enacted into law, or the basic law is enacted into law, then there will be preparations for a plebiscite. The plebiscites will then be undertaken once the results are published. Then we will know which local government units are part of the Bangsamoro Autonomous Region. At which point, a election will be held. Or rather, in the meantime, whilst this is all going on, because COMELEC has consistently told us that they will need 6 months after the enactment into law. They will need 6 months after even the plebiscite, because the plebiscite will determine who belongs to. So the voters list will have to wait until we know which LGUs are part of the Bangsamoro Autonomous Region. After that, an election will be held to determine who will be members of the Bangsamoro Parliament. Whilst all of that is happening, the transitional authority will take on the functions of government. And since ARM would have been abolished as the first effect or the first act of the organic law, then they will run the government, or they will begin to reorganize the government. And that is why one of the main issues is what will happen to the different offices. They are all abolished. All the items are the positions in those are abolished, but they can, of course, they're free to create. I would imagine also a similar position, because these are clearly necessary for the proper conduct of general governance. In any case, that is the general procedure. After, if and when the Bangsamoro government and the COMELEC are ready to have the election, they will have the election will be conducted. The members of parliament will be determined. The sectoral representatives will be determined. The party list will also be determined. At which point, the Bangsamoro Parliament will go into session, and they will cede the transition authority will then cede all their authorities running the government to the Bangsamoro government, as it will be organized by the parliament.
Right. Inasmuch as you have mentioned the Parliament already, let me move on to Section 35, the Parliament. Bangsamoro Parliament shall be composed of at least 60 members. May I know the basis for coming up with at least 60 members composition of the Parliament?
This was the original proposal in the draft BBL. We tried to conform to the original size as much as possible. I think, but that is why we did, however, include at our parliament, the Bangsamoro government, to make to increase the numbers. And, if it feels that certain districts are underrepresented, certain parliamentary districts are underrepresented, or if perhaps a new sector would like to have a sectoral representatives, then perhaps there could be new arrangements for further seats in the parliament. So that is the starting point, and it became the starting point simply because that was the proposal in the
original version.
That's right.
All
Mr.
right.
President.
All right. If we're giving that power to the Parliament to increase its number, when we say at least 60 members, does it mean that there could be unlimited members in its Parliament? We have guidelines, limitations, conditions
we do
for
not
increase?
we have not put any limit, no upper limit. Unlike, for example, where we have, in the case of congressional districts, there is a limit in the Constitution to 150 congressional districts, but even that can still be expanded. We still have the option of doing that. So I think perhaps what we could do to try again and follow the same logic that we have for congressional districts, we could introduce a threshold number in each district. For example, we in the Constitution now there is a threshold that after beyond which the constituency can then be organized into a new district. That is all the redistricting that we do. If the body feels that that kind of threshold number is useful, then we can certainly introduce that. But we try to stay as close to the original version as possible, and the original version of the draft PBL did not contain any limits or any, for that matter, any thresholds for the creation of new parliamentary districts.
Yes, well, you mentioned the House of Representatives in our Constitution. There is really a limit composed of not more than 250 members. This is Section 5 of Article 6. So perhaps we can introduce something like that during the period of amendments, Mr. President, if you don't mind.
Certainly, because
We will just try to find out how many would the possibility of members or representatives from the different districts.
The number flowed also from the situation, the organization now of ARM. And that was felt that the parliamentary districts, or rather, yes, the districts that are being used now were sufficient, I suppose, for the present. But again, the populations increase, there is a redistricting. So yes, certainly, I believe the logic that is used by in the Constitution to put a minimum amount by saying that there is a threshold, and beyond that threshold there should be or can be or they are qualified to be represented in the House of Representatives I think is sound, and perhaps that could serve as a guide for our own design for the possibility of the membership of Parliament being increased.
Well, the reason I brought it up is because there is a possibility that if they're allowed to increase and there is no limit, there could be 500 members of Parliament.
That's right.
Just for accommodating or for accommodation purposes.
That's right.
And then what are we talking about? They will probably be spending 70% of their budget for personal services only.
That's exactly right, Mr. President, and that is I believe that is one of the reasons why the number was at least conceived originally at 60, because to make it more manageable. Because as we can imagine, the more members of Parliament there will be, the longer and the more complicated the discussions will be, and it will be the prospect of gridlock, as we have seen in other legislatures, not necessarily in the Philippines, but in other countries. That is a distinct possibility if there is a very large, uncontrollable membership in the Parliament of the Bangsamoro.
Yes, thank you for that, Mr. President. Now that we have mentioned also the legislative department and mentioned the Constitution, I noticed that there is no under your Section 35. There is no provision under the Bangsamoro Parliament that prohibits the members of the parliaments to hold other office or employment in the government. This is a provision present in the article on legislative department in the 1987 Constitution. So, may we know why, or this was just omitted? They are not prevented from holding other office employment in government. Unlike
well,
us.
they are constrained from doing so because in the Constitution there is the government officials, elected government officials are disallowed.
All right, so we did not spread it here. No?
Well, I think it's not necessary again, but I take a very liberal attitude towards repeating or making a point or highlighting a law or parts of the Constitution that we feel must be invoked, so that we can so as to explain what we are doing. So again, if the body feels that that it is that we need to expressly state that what is found in the Constitution, I certainly wouldn't have would have few objections to that kind of idea.
Thank you, Mr. President. I will go back to my drawing board also and probably look if it's necessary. If not, then I will accept the answer of the gentleman. Section 36. You somehow were able to give us a gist on this, but let me just place it on record again. Is there a basis for changing the number of allocation seats from percentages in the old draft bill to actual number of seats in the substitute bill?
Yes.
Kasi yata, di ba, in the old draft,
It was
the
40
seat allocation for district representatives is 40% of the members of parliament. However, in the substitute bill, the seat allocation is now 40 members. Why was the number of district seats increased from 24 seats, which is 40%, to now 40 seats, which is 66%? Maybe you know the rationale for the
Yes,
change.
it is quite simple. Really, because we wanted to be consistent with the principles that were earlier, that are stated at the beginning of the basic law. That principle being that the legislature will be a democratically elected, will have democratically elected members, and that the parliament will be again a body that is a democratic one, a representative one, which would not be the case if less than half are actually elected and more than half are appointed. We cannot describe an appointed a legislature or anybody for that matter that has more than half of its members as appointed as a democratic one or a representative one. And so to keep that, to be consistent with the idea that the legislature should be representative and should be democratic in the sense that it gives equal representation to all the districts, and that the elected membership will have the final say in all that happens, all the laws that are passed, all the deliberations, all the decisions that are made by the Bangsamoro Parliament. Then I think if that is the case, if the majority are democratically elected, we can say with confidence that the Bangsamoro legislature is truly representative of the inhabitants of the Bangsamoro region.
Currently, how many district representatives does the ARM have?
80? They have, there are presently 18 district
18.
representatives in ARM. District representatives.
In party seats, from the old bill to the substitute bill now, why was the number of party seats substantially reduced from 30 seats, 50%, to a mere 8 seats, 13%?
The truth of the matter is, as this I have to be very candid. We just it was what was left over. Once we decided that there were going to be 40 seats that were elected, then you have the sectoral representatives, of which there are 2 each. There are 6 sectors that are identified, and that leaves now the number 8.
Where did we get the 12?
Again, this is something that has been brought up by a couple of other of our colleagues, and that this number might be too small. But again, we also must learn from the experience that we have in the House of Representatives, where there are presently now, if I am not mistaken, 192. There are 192 congressmen, and of those, over 50 are party list representatives. So that seems to be maybe the extreme in that case. And again, this was just a determination that was made, they're trying to learn from the experience and trying to see what other sectors, what other, shall we say, disenfranchised sectors would want to organize themselves into parties and to run under the party list system.
So yung sectoral, ito yung mga 12, ano?
12 sila dahil
12 sila.
6 yung na-identify na sector, tigalawa sila na maging representative to be chosen by the leaders of those different sectors.
When you say identified, did we determine already which groups may be considered as sectoral
Yes,
representatives?
we have. These were the groups that during the process of the hearing,
Ano po ito?
that came to us and said that we feel that this is what we were discussing the other day, that yesterday, that these are groups that said that we feel we have something to contribute. And because of that, and with their explanation, we felt that they should be part of the parliament, and to make sure that whatever the results of any election, that those groups are in fact represented by the sectoral representatives. In paragraph 3 of the same of section 36, we have the list or the enumeration of the different sectors that we have included. They are the non-Moro indigenous communities, the settler communities, women, youth, sultanates, and the representatives from the labor sector.
All right.
These are the 6 sectors that we have included as having two sectoral representatives in the Bangsamoro Parliament.
So are we saying that this provision that reserves the seats for them, they're only limited to a certain or one seat, regardless of the numbers of members in their respective sector?
That's right, Mr. President. It is a bit of a hybrid of the old system in the House, where we had appointed sectoral representatives. So but now we remove that idea, and we now have the party list representatives. This will have both. There will be sectoral representatives, although they are not appointed, they will be chosen by their sector. But it is felt that those sectors, we must guarantee those sectors' representation in the Parliament of the Bangsamoro, because of their particular and singular needs and issues, that they should always have a representative in the Bangsamoro Parliament, and that's why they have those reserved seats. So what in fact has happened is that we have now the elected members of Parliament from the different parliamentary districts. We then have the sectoral representatives who will be nominated and chosen by within that sector. And finally, there will be the party list, the equivalent of what our party list representatives in the House of Representatives now. So we will have a kind of hybrid, as I said, of what we had before in the House and what we have now.
Your last sentence in this section 36, I'm sorry. You say the Bangsamoro shall determine the manner, Bangsamoro Parliament shall determine the manner of election of sectoral. Why is the Bangsamoro Parliament given the authority to determine the manner of election of sectoral and other representation in the Parliament, considering that there shall be a Bangsamoro Electoral Office, which shall be part of COMELEC under Section 39? No?
Well,
don't you think the Bangsamoro Electoral Office is the better agency to determine the manner of election under the control and supervision of COMELEC yun?
It is not so much the actual conduct of elections, but again, it is merely to ensure that, in fact, who is put forward as a sectoral representative is actually the chosen representative of that sector.
So, pag sinabing
And that's why the Bangsamoro Parliament is going to be will ascertain that this is that will put together a system, make a system so that we can be guaranteed that the chosen sectoral representative is one that is actually chosen. It is not somebody that is imposed upon them by any other person, by the chief minister, by a very influential member of parliament, a cabinet member. That really is the intent of that sentence, is to have the Bangsamoro Parliament ensure that the sectoral representatives are true representatives of their sector.
I am enlightened. Now I see the point of the manner. You're talking of the manner, the Bangsamoro Parliament.
The conduct
it's
of
the
the-
manner. The conduct, of course. Is
Conduct of elections still remains with the common.
all right. Section 37, Mr. President. Election for reserved seats for non-Moro indigenous people. Is there a maximum number of seats for the non-Moro indigenous communities and settler communities?
As sectoral representatives, they have two reserved seats, and they will determine who those two representatives will be.
2 for non-Moro indigenous,
Yes,
and
that
then
is
2 for
reserved.
settler.
That is reserved for their sector.
Anong pagkakaiba po ng non-Moro indigenous communities and settler communities?
Actually, ang non-Moro indigenous communities, ang indigenous communities na hindi Muslim, na hindi sinasabi hindi kami Bangsamoro people. Kahit na matagal na kaming nandito, kasi kung tutuusin natin, ang mga Muslim sa Southern Philippines, indigenous people din sila. And this is only really to try and find to make the difference that the Lumads were asking for, that the IPs were asking for. And they were saying because of their cultural heritage, it is very important for them to maintain their identity as non-Bangsamoro. They have their own definition of their identity as a people, and they wanted to maintain that. That is why we came up with the term non-Moro indigenous people. The settlers are those who are not Bangsamoro people, who are not non-Moro indigenous peoples. They are the settlers that came after the both indigenous people, both non-Moro and Moro indigenous people, ang sumunod na pumunta sa Southern Mindanao, sa Bangsamoro Autonomous Region. Yan ang tawag natin ang mga settlers. The old term was Christian settlers, but we don't make that differentiation anymore because we have a more pluralistic view of the settlers than we had previously. So we now use just the word settlers.
All right. Were they consulted in the Bangsamoro creation or their inclusion in the Bangsamoro Autonomous Government Parliament? Were there hearings?
Who consulted, Mr.
The non-Moro indigenous communities.
Oh yes, they actually took the initiative to come to see me and asked for a meeting at which they gave me a briefing. And I said very well that they had some very serious concerns that certainly warranted attention. And so since we did that, then we organized a hearing just for the IPs and the different tribes, as the tribes that are mentioned here, the Teduray, Lambangyan, Dulangan, Manobo, Blaan, Higaonon are the ones that the main tribes that are mentioned as enumerated under, but they're not limited to this list. And so that they were consulted, and as a matter of fact, there was a very perfunctory mention, almost in passing, in the original version, and it said that the ancestral lands and rights of the non-indigenous peoples will be respected. That was a very, very simple, and they felt the IPs felt insufficient guarantee on the preservation of their rights and the protection of their ancestral lands. And so the detailed organization that are specific for non-Moro indigenous peoples, in fact, were the product of those hearings, and much of the language comes from
Dinagdag
them
niya.
and their representatives.
Maganda yung dinagdag ninyo rito sa version nyo, that these two reserved seats shall have the same rights. This is not found in the original bill, no?
That is not, Mr.
Yes,
President.
all
What
right.
is found in the original bill is just one sentence that says that their rights will be respected. We wanted to be, again, since this is always an area of conflict or of misunderstanding, that is the area of the ownership of land, of ancestral domain, with various claims being made on the same piece of property, both on ancestral domain and for other cultural and historical reasons. We felt that to make it very, very clear what are the rules, what are the laws that we are applying, we thought that it would be good to have an additional, to add more detail into the actual structure of within the Parliament, and to give a very clear understanding of how the ancestral domains and again our IPs are treated within the Bangsamoro region.
Thank you. Yes, well, I wish to congratulate your committee for that.
Thank
Very laudable. Now, Section 38, regional parties. The provisions states that only regional political parties duly accredited by the Bangsamoro Autonomous Regional Electoral Office may participate in the parliamentary elections. Are there any requirements or guidelines as to the qualifications of these regional political parties?
Well, this is the party list. When they say regional political parties, what we mean is that these are parties that exist in the region, not
see.
outside the region. So hindi naman pwedeng the Bicolano Regional Party tatakbo dito, or the Waray Regional Party. Hindi.
No, I mean, but within them, within,
it is within
no?
the
Oh, right.
region. Yung ibig ang paggamit ng salitang regional, ibig sabihin na nandoon sa Bangsamoro Autonomous Region. So, etong section 39 section 38 is essentially the description of the party list system and of the party list representatives. So, pag sinabing only accredited by the Bangsamoro Autonomous Regional Electoral Office, this is exactly the same, or rather, this is parallel to the way COMELEC determines whether or not a party list is in fact representative of a disenfranchised sector.
So, regional parang party list ito, ha? Hindi ito yung political parties like there is a political party in Region 3.
Oo.
Di sa Nueva Ecija,
Yung mga
sila Hoson.
hindi no.
Oh, iba yun, ano?
Iba yun. Those are local mga
Political parties.
Local
Oh, yeah.
political
We do
parties.
not mean them in the
We do-
these
we-
regional political parties.
No, we do not. We do not
Oh.
mean them. But I can see that maybe we maybe
We
can
might have to insert a word or two
parang,
just to clarify that. Sa akin, yun ang unang dating eh.
Oo.
May mga regional political parties, hindi mo ba, in different provinces.
So, maring
One Cebu, for that matter, no?
maraming ang pwede nating mailagay is regional political parties from the Bangsamoro Autonomous Region.
All right.
Well, anyway, that is
Anyway, sige.
something that we
Sige
can
po, sige po.
make
Yes.
more clear.
I agree.
as
Thank you
we
very much.
go
Thank
through
you.
the bill.
Now, Section 39, Bangsamoro Autonomous Regional Electoral Office. May we know the difference between COMELEC's regional office and the Bangsamoro Autonomous Regional Electoral Office in terms of their functions, structure, and relation to COMELEC?
In terms of their relation to COMELEC, there should not be any difference because it has to be made very clear. Because of it is again a constitutional question as to the organization of COMELEC and a separate electoral commission in the Bangsamoro Autonomous Region. So the Constitution only allows for one electoral commission, and therefore we have kept the Bangsamoro Autonomous Region Electoral Office under the control and supervision of the COMELEC. In terms of the function, there may be differences simply because they are administering a different political system. In the in all our other political subdivisions, we only talk about the chief executive, we talk about the Sanggunian, and our usual political system. This is something else, and I imagine they will have to create some new procedures, new methods of administration, simply because the system is different.
So when you say under the control and supervision of the COMELEC, you mean that all elections in the Bangsamoro Autonomous Region shall be subject to the Omnibus Election Code
That is exactly
and
correct.
pertinent COMELEC issuances?
That is right. And again, there might be a need for specific issuances that pertain to the Bangsamoro, the conduct of the election of the Bangsamoro, the membership of the Bangsamoro Parliament. But aside from that, the principle, again, was to keep it, number one, to make it very clear that the electoral office is very much part of COMELEC, and hence the constitutional infirmity that was first identified is remedied. Secondly, we tried to keep it similar, again, to the COMELEC regional offices as we have around the country. But perhaps because there is greater autonomy in the Bangsamoro Autonomous Region, and also because it is itself a political subdivision, then there will have to be there will have to be more enhanced functions in the Bangsamoro Electoral Office. Because the regional office of COMELEC is only an administrative has administrative function, whereas the function of the monitoring, the regulation of the actual elections falls to the provincial offices, the city offices, and the municipal COMELEC offices. There will be no such offices any longer. Besides the local government, aside from the local government units, but at the regional level, it will be directly monitoring the elections of the actual Bangsamoro Parliament.
All right. Thank you very much. I cannot help but compare it with the old bill. I noticed that Section 8 in the old version, redistricting, was deleted. Now, in relation to the creation of the Bangsamoro Regional Electoral Office, does this mean that COMELEC through Barrio will now exercise the function of redistricting in the Bangsamoro Autonomous Region, or you just simply deleted it?
No, we simply deleted it because we again, to give as much autonomy as possible, we will allow the definition of the parliamentary districts to fall to the Bangsamoro government. In the very start, it will be the Bangsamoro, it will be the transition authority. To start to organize, they will define which are the ministries that they would like to continue with, which they would like to reorganize, what new ministries will also be organized, and how to define the parliamentary districts, so that there were many suggestions, and probably the easiest one is to consider what is already happening in ARM, where we basically divided each congressional district into three, to put three districts in each congressional district. There is always a worry that this will be cause for confusion. But looking at the experience in ARM, it would seem that it's a workable system.
Mm-hmm. Section 9 also, you also deleted this. That means the Omnibus Election Code will apply. You deleted the Bangsamoro Electoral
right.
Code, no?
That is
so,
right.
So, Omnibus Election Code na rin, ano?
Yes, we were, of course, trying to avoid any implied amendment of a national law. We are trying to avoid any conflict or inconsistency with the national law. So
All right.
Again, the electoral code is a national law and must apply in all parts of the Philippines.
Just for clarity, Mr. President, the last paragraph of Section 39 states that the Commission may delegate its powers and functions through the heads of its field offices. May we know what does the bill contemplate by the term field offices? Is this the Barrio or the COMELEC regional offices?
The Barrio is simply the COMELEC office in the Bangsamoro Autonomous Region. I think that's the easiest way to explain it. But then the different provinces will still have their provincial COMELEC office. So the field offices are those subsidiary, subordinate offices to the Barrio. But again, it must be made very, very clear. It must be very well understood that is the local office
Yes.
in the Bangsamoro Autonomous Region of the COMELEC.
All right.
Kailangan
Precisely.
maliwanag na maliwanag
Yes,
yun. Dahil
precisely.
importante
That's the
yun.
reason I wanted you to spread that into the records. All right. Thank you. Now, let me move on to Section 42, qualifications. May we know the reason why the residency requirement for members of parliament is 3 years? Is there any basis for this? Is this reasonable, considering that the required residency for congressmen is only 1 year?
This is actually again lifted from the draft BBL, and this was what was agreed upon by our negotiating panels, and we felt that if that is the requirement that they have agreed on. Presumably, this also was a request from the MILF side. Then I think that we should be consistent and say that if that is the proposal, and it is possible to fulfill that proposal, then we should do it. So again, it comes from the negotiations of the framework agreement, the 3-year residency requirement.
I see. Well, to continue, still on Section 42, you provide for the qualifications of a member of the Parliament. A person who wishes to be elected as a member of the Parliament must be, quote, a registered voter in the Bangsamoro Autonomous Region. In the 1987 Constitution, one of the qualifications to be a member of the House of Representatives, which is similar with the member of the Parliament, is that he or she should be a registered voter in the district in which he shall be elected, except for the party list representatives. Shouldn't the same rule be applied in the Bangsamoro Parliament?
That would be part, again, of the, I believe that is covered already by the election code, that the residency, you cannot represent a district in which you do not reside. So that I believe that that contingency is already covered by the Omnibus Code.
Well, remembering the fact that you do not mind a repetition, perhaps it would be best if we could include that also, a registered voter in the district, in the Bangsamoro Autonomous Region.
Again,
something to that effect.
Any language that
All right.
clarifies is always welcome, Mr. President.
In the same section, it states that the parliament member must be a resident of the Bangsamoro Autonomous Region without any qualifier, as opposed to Section 58, relative to the chief minister, which provides that he must be a bona fide resident of the Bangsamoro Autonomous Region. Why is the reason why such qualifiers lacking in the qualifications for a parliament members?
I
Ano ba yung,
I think this falls very much into the area where this is according to style.
Okay.
The language,
All
we
right,
can make
all
the
right.
consistent the language.
So
we
there's
can
no,
make the
there's no
language
real
consistent.
reason for it. Medyo na ano lang. Okay.
Because the process with which the substitute bill was written was to start with the draft BBL and to make whatever amendments we felt were necessary. So some were carried over the language verbatim. Some, in some areas, we created our own language where we felt it was insufficient. and that's why there might be some inconsistencies and in the language when the meaning is in fact the same.
All right. Thank you very much for that. Now, Section 43, salaries of Parliament members. The prohibition for Parliament members to receive during their tenure other salary and emoluments from the Bangsamoro Autonomous Region was deleted. Section 13, paragraph 3 in the old version. This deletion may be, well, I don't know, it might be abused. Moreover, if the Parliament members are to perform functions similar to our senators and congressmen who are prohibited from receiving other salary or emoluments from the national government, they should also be similarly prohibited from receiving other salary or emoluments from the Bangsamoro Autonomous Region. May we know the view of the sponsor on this matter, Mr. President?
Well, the Constitution, again, does not allow any elected official to hold any other offices or to receive any kind of consideration from any other party except from the national government. Therefore, that constitutional directive will also apply to this.
And therefore, it does not mean that we are allowing them when you deleted this.
No, we will stay consistent that all elected officials are not allowed to take on other jobs while they are serving in that capacity as a representative.
Now, in contrast, in the old bill, the original bill, there was no specific salary grade that was stipulated. In this proposal now, we are prescribing the minimum monthly compensation of salary grade 27. You are receiving a salary grade 31, Mr. President. So why are we keeping them at salary 27? Is there a reason for that? Congressmen and senators are salary grade 31.
Well, again, this is something that we patterned to local officials again. Whenever we needed guidance, we went back to the situation in local government. With the reminder, with the thought always that this is not the same as a regular local government. It is in fact an enhanced form of local government.
Presently, the parliament members of ARM, ilan sila?
Do we know what anong pay grade?
Salary grade. The mayors are salary grade 27, I know.
Anong pay grade ng ARM assemblyman? We will look for that pay grade of the present ARM assemblyman.
Well, it's all right. I was just trying to compare it, but I see your point. I see your point. I have no proposal on that particular section then, Mr. President. Section 44, disclosure. Where and when shall the members of the Bangsamoro Parliament submit the disclosure of their financial and business interests, including those of their spouses and children? Are they covered by the SAL-N law?
They will,
obviously.
Sir. They will be covered by the SAL-N law as government officials.
Where and when shall they submit their disclosure?
I believe the schedule for the the elected officials or rather the government officials in the Bangsamoro Parliament and the Bangsamoro government will have to follow the same schedule that we do, that the rest of the country does, and we have our usually we have our deadline for submission of the SAL-N in April, and they will have to follow the same schedule as us.
Well, I only ask because
the rest of the elected
magiging iba yung panahon na mai-elect sila sa atin, no? But they'll maintain the timetable. All right.
That is actually why we did not put a timetable.
Okay.
Dahil nga you'll find that feature in many parts of it, because for example, in the local bill and in the organic law, there are instances where we say that the first regular election will be, but we cannot say with any certainty when the first election will be. So only the first regular election is what we can talk about. Because hindi na nga natin malaman kailan matatapos ang proseso dito sa legislature, kailan matatapos ang plebisito, kailan matatapos ang halalan. It was impossible to put a date and in a strict schedule.
I was going to go there later, Mr. President, but
I would assume that before assumption into office, that the SALN would have to be submitted. I think like any new official that enters government, either as in an appointive or in an elective capacity.
Section 44 also states that the members of the Bangsamoro Parliament shall notify the Bangsamoro Parliament of any potential conflict of interest that may arise from the filing of bills or resolutions of which they are authors. Pareho sa atin dito. Now, the provision, however, does not state the period within which the member shall notify agency or person whom they submit their notification and any penalty for the failure of notification.
From looking at the language, it would seem to imply that upon filing of such bills, if there is a clear conflict of interest, that has to be revealed to the Chief Minister who heads the Bangsamoro Parliament. In the same fashion that we have that rule in the Senate and in the House of Representatives.
Ano? Clarify? Yeah. I hope you don't mind. We will try to to figure a way to propose, figure a way in being able to propose perhaps an amendment to clarify that and cover what you said, Mr. President.
Certainly,
Now,
Mr. President.
thank you, Mr. President.
Again, is most welcome.
Now, there is a prohibition on Section 45 against conflict of interest. Is the prohibition against conflict of interest also applicable to immediate family members of the member of the Parliament?
As it is written, that is not the case.
Why not, Mr. President?
We felt this was also lifted from the draft BBL. Oh, this is directly lifted also from the draft BBL. And so we felt that again, perhaps because the constituency that they will be covering is rather small, it would be a fairly very limiting rule. Dahil kung maliliit, if you can imagine, there is one there in each congressional district. For example, there are 3 parliamentary districts. If the member of parliament from that district, if their family are not allowed to conduct any business, paano maghahanap buhay naman yun? Dahil maliit lang ang kanilang pinanggagalingan.
All right. I see the point, Mr. President. I agree. Section 46, forfeiture of seat. How many times can a party replace its representative in the Parliament, Mr. President?
We have no we have no rules in the organic law, but we will follow again the organic law, the omnibus electoral code in that regard. So the rules that apply to the party list representatives will apply to these party list representatives.
One of the grounds of your forfeiture of a parliament seat is the conviction of other crimes punishable by more than 6 years. Considering that crimes only cover those punished under the revised penal code, should we not include offenses punishable by more than 6 years to include acts punished by special laws?
We could include that, but we just kept it consistent again with the immunity that is enjoyed by legislators in the national government.
Ganon din more or less yung proposal namin sa Section 48 sa privileges and immunities. No, the exception to the immunity parliamentary members from arrest while the Bangsamoro Parliament is in session is only for crimes punishable by more than 6 years of imprisonment. Same with, well, but I believe what we should include offenses punishable by more than 6 years of imprisonment to cover violations committed under special laws.
Would the gentleman care to expand on that so that we get the idea what the intent of including that language would be?
Meron kasi tayo mga laws that are punishable which are not included in the revised penal code. There are new laws that we have enacted. Yes, legally I think they do not call it crimes, they call it offenses. So,
but again, I think that is why I felt that those the definition of the crimes that for which there is immunity, it is for the guide still, not so much the crime as much as the crime being punishable by more than 6 years. Or rather less, by less than 6 years. So whatever law, be it within the penal code, special laws, or otherwise, they will still apply if those laws are impose punishment of anything less than 6 years, then the immunity will apply. If, however, the punishments that are provided for are more than 6 years, then the immunity no longer applies to the members of Parliament.
So you do not mind if we say that it includes the special laws, huh?
I don't think so. I don't see. I think we will have to look at the laws.
Like for example, the Dangerous Drugs Act. It's not included in the revised penal code. It's a special law.
Well,
the distinct
the author said that it is based on the penalty, regardless of whether it is the revised penal code or special law, if the penalty is not more than 6 years.
So pareho lang.
What we could do, because the special laws call the violations offenses.
Yeah,
So we put crimes and offenses that are punishable by less by punishable by less than 6 years, when the immunity still applies.
Yes, that's in other words, whether it's the special law or the penal code, the basis is the length of imprisonment, the penalty.
That's why
that is why we feel that it covers even those the special laws that are not in the penal code that we refer to as offenses rather than crimes.
All right. We just want to clarify that. So, well, I hope we can try to insert a word or two to clarify the particular issue, Mr. President, at the proper time. Thank you. Filling of vacancy, Section 47. In cases of vacancy involving an unaffiliated member of Parliament, is there a required period of unexpired term for holding a special election?
Again, this is something that COMELEC has already ruled on in our in the case of both the Senate members and the members of the House of Representatives. I believe that if the terms, as is laid out, since the terms are of the members of Parliament are the same as the term length of the members of the House of Representatives, then the same should apply in terms of special in the case of special elections being conducted. And I think the rule is simply if there is less than a year or less left in the term, then there is no need to have an election. Anything more than that, a special election is conducted.
All right. Thank you, Mr. President. Your Section 49, moving on, deals with the session of the Bangsamoro Parliament. Its regular session shall begin on the 15th day of June, after 30 days before the opening of its next regular session. May we know what is the reason for the committee to come up with such a date? Because in Section 15, Article 6 of the Constitution, 1997 Constitution, the Congress shall convene on the fourth Monday of July. Now, would such difference in the opening of the regular session give the impression that the Bangsamoro Parliament is not under the general supervision of the President, who addresses Congress during the opening of Congress?
No, Mr. President. What we have here is simply because the elections are held in the Bangsamoro, as they are being done now, in ARM, before the general elections, the national and local elections. So to have the same period where between the elections occurring and the assumption of office to be the same, to be consistent, we have given the same number of days, the same amount of time as we have for all other elected officials, because our elections will be held 1 week or before, rather after that of the Bangsamoro Parliament. The same system that we have now with ARM.
All right. Thank you for that, Mr. President. Now we understand. Section 52, Mr. President, Rules of Procedure. You provide that the Bangsamoro Parliament shall adopt its House rules for the conduct of its business. Same section, however, does not provide a requirement of publication for its effectivity. Alam na natin ang nangyayari pagka mayroong issue ganon. So will the House rules be binding even without publication?
That again will depend upon the rules that they adopt. Again, we are coming up against the whole idea here of autonomy, and we try to minimize whatever rules that we follow and impose them on the Bangsamoro government. The whole idea of autonomy is for them to conduct their business in whatever way they see fit, so long as it is legal and so long as it is responsive to the needs of their constituency. So.
Well, I suggest that we include a publication because lalo na pag may mga penalties, Mr. President, mahirap i-enforce pagka wala kang publication. We have experienced that issue.
The requirement of publication is a constitutional one also. Therefore, there's no need to, we felt again, since the Constitution is clear on that issue, that there is no need to repeat the provision in the organic law. However, once again, going back to what I had said before, should the body feel that this clarification is necessary, that the constitutional requirement of publication be repeated in the organic law, then I certainly would not object to such language.
I will propose that, Mr. President. I think it's necessary. Thank you very much. On number 53, proceedings. Why is there a need to translate the legislative proceedings of the Bangsamoro Parliament in 3 languages, specifically Filipino, Arabic, and English?
This is simply to make certain that all the inhabitants of the Bangsamoro Autonomous Region will have access to the proceedings in the Bangsamoro Parliament, and the dominant languages in the Bangsamoro Autonomous Region are those 3: Filipino, English, and Arabic. In like fashion, we translate often from Tagalog to English in our transcripts. We do not have the requirement to translate it into Arabic, but that is something
Yes, not even in Filipino.
Well,
English.
But if we speak in Tagalog and we translate into English, just so that everyone has access to that. But it was felt that that is not sufficient in terms of providing access to the transcripts of proceedings. That English would not be sufficient, and that the other languages are needed.
All right. Do you feel it is not tedious, costly? Do you speak Arabic, Mr. President?
No, Mr. President, but inshallah, I will learn one day.
Don't you think so, Mr. President?
This
Di
is
ba costly ito, tedious ito, mag-Arabic ka pa.
I do not think so. If we are able to manage a translation from Tagalog or Filipino into English, we get our transcripts a day, 2 days after even long speeches that are being made or long deliberations that are conducted in Tagalog. We are able to do that. Secondly, this is also, I guess, for record-keeping purposes. This is the translation. The provision on translation is actually again lifted from the draft BBL.
All right.
And so the framers of the draft BBL felt that there was a necessity to include Arabic in the translation of the transcripts of the proceedings of Parliament.
Ang ibig niyo pa sabihin yung when people speak in Arabic or speak in Filipino, they translate in English later on when they do the journal. That's fine. I have no problem with that. The way I understand this is, I may be wrong, is that we are asking that the legislative proceedings be translated.
That is how I understand it, Mr. President.
There will be three.
There will be 3 copies.
3 copies in Filipino, in Arabic, and in English.
In English.
Ganun ta.
Despite what language the proceedings are conducted in.
Mahirap. I mean, mahaba, Mr. President,
There were
matagal.
actually before.
Ha?
Original.
Ano yung pang-apat?
Yung kung ano yung, halimbawa, tayo, nagtatagalog tayo ngayon, may transcript na kasama Tagalog, kasama English. Merong isang transcript, English lamang. May transcript, Filipino lamang. May transcript, Arabic lamang.
Yeah, the entire proceedings will be translated in Arabic.
Into Arabic, yes. That is the...
From the time they bang the gavel to up to the adjournment?
That's my understanding of
Oh
the
my
provision,
God.
Mr. President.
Well, it's up to them. It's really, that is
Well,
very tedious, as I said.
I do not feel, because maybe we feel that way because we are not fluent or familiar with the Arabic language. But those who are, I do not feel that they would find this an extraordinary imposition to translate it is as easy for an Arabic scholar to translate Tagalog, Filipino, and English into Arabic as it is for our transcribers to translate our Tagalog into English. So I believe that it will not be too much of an additional imposition. Again, it will be the Bangsamoro government, the Bangsamoro Parliament can choose if they feel that this is a requirement that is difficult to fulfill. They can change the rules and say that we only translate it into English or we only translate it into Filipino.
So this is not mandated. In that case, are we not mandating it?
Yes, we
Yeah,
are,
all right.
because
We
that
are,
is that was the proposal that was made.
Example lang po, Mr. President. There are words in Filipino that are difficult to translate in English. There might be words and many words in Arabic that will be difficult to translate in English, or English that will be difficult to translate in Arabic. To give you an example, if I ask you a question and ask you to ask a common fellow, you might be able to do it, but a common member of parliament, ask him to translate to English the phrase or the question, pang-ilang Pangulo ng Pilipinas si Ferdinand Marcos? You translate it in English.
We will find a way to
Yung
translate
pang-ilan.
it in English, but it will not be as simple or as elegant as it is in Tagalog.
Correct. That's what I mean. Hindi kaya magganon din yung
But
Arabic?
I believe that exists in all other languages. The Tagalog, I have found, is an extremely expressive languages, and there are words in Tagalog that will take a paragraph of English in translation.
Correct.
But I believe that is the case in all of our proceedings, where there are, when we speak in Tagalog, sometimes it is difficult, and it certainly, the nuance of the language is sometimes lost, the proverbial lost in translation. But again, there is still a way to express it, not as elegant, not as simple,
not as simple,
not as expressive.
Correct.
But the general, at least an idea will come forward. But again,
there will be a direct translation, but it will take a paragraph, perhaps. Like for example, that particular
instances.
Yes, that particular question. Pang-ilang pangulo ng Pilipinas si Ferdinand Marcos?
Well, what you would intuitively want to say.
Marami magtatangka, how many? Or
Pang-ilan is the difficult.
That's the key. That's the key. That's the difficult one.
Pang-ilan, there is no direct equivalent in English.
Yes, I know.
Also, my example is the word kapaki-pakinabang.
Yeah.
I have challenged everyone to translate that into English, and we have not a direct translation. So these are instances that come up with Tagalog. I have no doubt they come up in every other language when we try to translate it into another language. But as what little I know of the Arabic language, I know that it is as expressive, as romantic, as beautiful as Filipino. English, I think, is the one that falls behind when it comes to those qualities as a language.
I agree with you. It will take a paragraph. Like, for example, the direct translation or the best translation of the question I gave you, which is pang-ilang pangulo ng Pilipinas si Ferdinand Marcos. The best way to translate it in English is in what chronological order does Ferdinand Marcos fall in as President of the Philippines? It will contain the question, but it is a paragraph.
Oh, so clumsy and inelegant as compared to the Filipino.
Yung kapaki-pakinabang could be very useful.
Kapaki-pakinabang. Oh, yes. But when describing a person,
yes,
as in our oath,
it takes a different color.
It immediately, it is not the worthy or useful is not sufficient.
I think the topic has been sufficiently
Can
we move on to the next
topic?
topic?
Mr. President, we are enjoying ourselves making these comparisons, but thank
maybe
you
we
for
can move
reminding
on to the
us that we have a bill to pass.
We are just trying to infuse a little levity.
I know.
Thank you, Mr. President. Now, let me move on then to Section 55, Appropriations. Should the annual appropriations law be made part of the national government's General Appropriations Act, considering that the Bangsamoro Autonomous Region is supposedly still part of the national government? At the very least, there should be some check and balance to guard against possible abuse.
Again, the rules that will apply to that apply to the creation of the General Appropriations Act will be the same because the accounting principles that will be applied will be the same. And so the appropriations must be done properly. The implementation of the expenditure and the administration of the expenditure should be the same as what is being done in the House of Representatives. But we have to again remember that this is a second step. The other slight difference is that presumably after certain number of years, that the fiscal autonomy of the Bangsamoro Autonomous Region will be complete in the sense that they will be what they will be spending is what they will be able to collect or whatever funds they will be able to generate. So it is now, again, because in the interest of autonomy, we leave it to the Bangsamoro Parliament to decide how to appropriate those funds. And again, as long as they are consistent with generally accepted accounting practices and general principles of financial management, then again, I see that there should be no problem. We cannot interfere we should not. If we are to make this a real autonomy, we should not interfere in the appropriations.
So how does it work, Mr. President? They will no longer be included in the GAA.
Well, that is that after the concept is that in the first 5 years that there will be assistance given by the national government, even the tax collections. That was another bone of contention, that the tax collections will be how much will be given to the national government, how much will remain, and the proposal was 100% in the Bangsamoro government. But that is in the transitional period. One of the great complaints about ARM is that how can you call us autonomous when we have to go to Congress every year with our begging bowl to ask for appropriations for us? So that is still dependent. That is why there were additional powers in revenue generation, so that again, fiscal autonomy has two aspects to it, has two sides to that coin. One is that you have the autonomy to spend what money you yourself collect. So that is the fiscal autonomy that we are talking about. So if you put aside the transition period, presumably the Bangsamoro Autonomous Region will generate its own income, it generate its own funds, and therefore the sources and uses of those funds, of Bangsamoro government funds, will be determined by the Bangsamoro Parliament.
Well, I have some apprehensions on this, but I will not belabor the point at this point. Allow me to probably review my concerns about it.
I believe that it is for us sometimes counterintuitive to allow these powers to be exercised, but whereas our tendency is to be very, very clear when we are deliberating legislation, to be very, very to not leave these decisions as open-ended decisions. But that is because we have not talked about this much autonomy, and we have to keep reminding ourselves that you cannot impose all of the rules. We must allow, if it is to be a true autonomy, we must allow the Bangsamoro government to make those decisions that they are in the conduct of the governance of the Bangsamoro region.
Mr. President, basta't pera nila, it's okay. Appropriate nila. I have no problem with that. If it's from the national government, then there should be some check and balance. That's the only reason that I was asking that.
The shall we say, protection that we depend upon are, again, the COA, making sure that the expenditures are properly implemented, and secondly, the DBM in their oversight capacity, that they will say that these are proper expenditures, these are proper appropriations. So that's why, to use again the example, that if the Bangsamoro Parliament somehow passes an appropriation to buy a toy submarine, then of course the DBM will say this is improper, and so that will not be allowed. If again the bidding process for any kind of appropriation is improper, the COA will step in and will say that this is improper, and we will have to re-examine it further. So again, those are the safeguards. So long as there is, it takes a little time to back away from the kind of control or the kind of mandates that we usually provide for local governments. And we have to keep reminding ourselves that this is precisely the meaning of autonomy. That these decisions that we normally make at the national level are now given to the Bangsamoro government for their own perusal, for their own discussion, for their own wisdom and judgment, and how it applies to the region. So the minimum amount of shall we say monitoring regulation would have to be the desired situation. As little as possible, as much autonomy as possible.
All right. I will move on, Mr. President. Section 57, reenacted budget. You provide for a reenacted budget. May we be clarified as to whether the reenacted budget will exclude capital outlays in the same way that a reenacted GAA would exclude such appropriations, Mr. President?
The concept will not really change because that is the definition of the reenacted budget. A reenacted budget is understood to only include the no procurement. Only the reenacted budget is only continues for the operations of the different departments of government, of the entire bureaucracy itself. It does not provide for any new initiatives. In the same fashion, those rules will apply to the reenacted budget of the Bangsamoro autonomous region, should it be necessary.
All right. Thank you, Mr. President. Before I move on to the qualifications and the next section, Section 58, I will beg the indulgence of the sponsor, Mr. President. I would wish to suspend my interpellation. I have been informed that the Secretariat was supposed to be out by 5 o'clock because of the holiday on Friday. So it's a little past 6 o'clock. So if you do not mind, Mr. President, and the sponsor, I will just continue on Monday on the remaining part of the Part 2, Mr. President.
I see no problem with that, Mr. President.
How many parts will it be, Mr. Senator?
4 parts, Mr. President.
Huh?
4. I will try to limit it to 3.5.
We hope you can limit it to 3 so that by Monday we can finish the whole...
Just as a point of information, does this mean that we have concluded Part 1 of the second part of the gentleman's interpellation?
No, Mr. President.
Just for clarity's
Part
sake.
1, yes. Yeah.
Okay,
Part 1 of Part 2.
Thank you for that point of information.
I will continue on Monday with the second
we can
part.
call this bill again on Monday. We can calculate it for the continued interpellation of Senator Sotto.
Thank you, Mr. President. I wish to thank the sponsor for being patient, and to you, the Senate President, the Majority Leader, and to whoever is listening, because I wanted to find out who are the members of the Senate who are listening to us. This is a very important matter. But anyway, thank you, Mr. President.
Thank you, Senator Sotto.
Thank you, Mr. President. Thank you to the gentleman from Quezon.
Thank you to the sponsor and to Senator Sotto. We assure him we are listening, Mr. President. And with the consent of the members, I move that we suspend consideration of Senate Bill 2894.
Suspended.
So, President, there being no other business to take up, I move that we adjourn session until 3 o'clock in the afternoon of Monday, September 28, 2015.
Session is adjourned until Monday, September 28, at 3 o'clock in the afternoon.